Amazing how.
Thought I'm gonna print a chair over here for you because,
Life on something like
come
that.
over here.
I get it.
Right here.
I'll be really figure out your. They can,
Yeah, it's hitting the clients
Do we need to
today
do
and what
music
else.
upstairs?
Hey, sorry.
Having your bag behind you.
We can kind of squeeze in more too.
Yeah, we should, we're roomy down here.
Well, my gas station got moved to closing in April.
Oh, gosh.
Gee, that's for the,
You have to be a patient agent of all that
Oh,
one.
the guy, the partner to the guy that's buying it, he has 2 gas stations that he had to close first. And so that's what knocked me out.
No, it's 11 o'clock. We're gonna start it off now. And again, if we can keep the chatter here to a minimum, I know how much.
We can go on mute if he's presenting.
Yeah.
We'll go on mute.
So, we're really lucky to have Jeff Litfin with us this morning. I'll let you do your introduction, Jeff, but I think we met, 12 years ago, something like that. And, as I said
Yep.
before, yeah, I thought I knew something about wills and trusts, and turns out I didn't know anything at all. So that's why we have Jeff here today with us. So, Jeff, you can just introduce
Don't be-
yourself and take it from here.
Kevin, don't be so hard on yourself. You were just fine, so. Anyways, do you want me to just
Yeah.
get rolling here?
Fire it up.
Okay, well, thank you all for having me out. Some of you I've seen before, and some of you have kind of probably sat in one of our classes in the past. So I'm Jeff Litfin. I'm a certified estate planner over here at Generations Law Firm. And yeah, we've had the opportunity to help several of your team members, including your fearless leader there with your nice flowing white hair, Kevin. I wish I had hair like that, but I don't. I'm just happy I have hair at this stage. Sorry, Rick, you have a little less than I do, but it's okay. Well, hey, we're going to get into this. Thank you for having me out. Now, normally this is a class that's about 75 to 90 minutes, and Linda, I think you said I probably should focus on 30 to no more than 40 minutes, right? So we're going to get rolling. I do have my chat kind of open. If anyone needs to send a message, it might be easier to just either raise your hand or just pop in if you have a question as we go. But Kevin, is there anything you wanted to say before I just start rolling, or should we just get into the content?
No, that's since we have kind of a time constraint, let's just get rolling.
Okay. All right. Well, I'm going to share my screen then with all of you, and you'll just be able to see the PowerPoint here, and hopefully that will come across. Is that coming through okay?
Yep, that's working.
All right, very good. Well, we're going to get rolling, and I'm going to go a little quick, but just know, Kevin, if you wanted, I could send you a copy of the slides when we're done. If any of your team members wanted to have that, that's perfectly fine. We would just, and there's a lot more in the slides than I'll probably cover today just because of the time constraint. We'll try to hit the highlights and go from there. And all we would ask is that you just don't throw it out online, out there for free, but you can certainly use it for your own educational purposes or internal training. So anyways, this class is a pretty popular one. I don't know if there's 2 documents that are more misunderstood or with more assumptions and false thoughts on how these things work. And we're going to kind of talk about wills and trusts today. So as we get going here, I always have to say this is education only. Remember, I'm not the attorney. I'm a certified estate planner. I do this every day. I always say that I'm the nurse, but the attorney is the doctor. And we've got 2 attorneys, soon to be 3, actually 4 here inside our firm. And they do all the drafting, but I pretty much do everything else as the paralegal, as the estate planner, so to speak. So that's kind of how we operate together. I always have to say it's not legal, finance, or tax advice, but everything we're going to talk about this morning falls into these 3 circles. Estate planning is more than just talking to a lawyer. And you're gonna learn that as we go forward. And normally we have a 2-part approach, kind of a public part 1 like this, and I'm glad all of you are online. And then for anyone that wants to follow up, any of you on the webinar this morning will have an ability to take advantage of a complimentary review, Kevin and others have done this. We don't solicit. We're not going to push you, but it's a way you could come in privately and have a little one-on-one, and we can do that over the phone or virtual or here in person. So just know you'll have that available to you. If I was sitting with you, I would have handed out a nice folder with some inserts. We'd have a yellow card in there. There'd be another document about our team. I know we don't have that today. So all I want you to remember is if you want to follow up with us or if you have any other questions, you can always contact me directly or just go to our website and you can request that follow-up, if you wanted to do that. And it's right there on our main homepage at our website. So anyways, that's out there. So let's get into it. Wills versus trusts. For all of you as realtors, we work with a lot of brokers and realtors. I wish we worked with more, Kevin, folks like you and your team. You got this. The light bulb went off for you, some years ago. And for other people on your team, it has as well. This topic of estate planning is important, not only for all of you personally, but for you professionally, because you folks are helping people buy and sell real estate every day of the week. And guess what's the number one problem, the number one asset that gets screwed up when people pass away? It's real estate, because they never think through the way the property is owned, the way the deeds are structured. There's no transfer mechanism. Well, I got my will done, Jeff. Well, that's not enough. A will is a set of instructions for a probate judge. So I want you to learn a little more here that we normally do. This is important because the way you people can help, we're talking about serving your clients a little more deeply than just getting through the closing and everyone's happy and we all go home. But we could take it a step further if we educate your clients, because you sold them the property, but how are they going to protect the property in the future? So that's one thing I want you to be thinking about. You have a really unique way to distinguish and differentiate yourself as realtors out there in the sea of real estate with all these other competitors you have, by just taking this a little bit further. So that's why I love it when I can share some of this information with realtors. But to this day, I'm surprised that so many don't really do this. So I don't know if I'm going to go into some of these steps here. I'll probably let you grab the PowerPoint here later. But bottom line is, we all want to sell. We all like the commission check. We all want to, pay the bills. There's nothing wrong with selling. I'm getting a little feedback now. I'm not sure why that happened, but I'm going to keep rolling here. There's nothing wrong with selling, but let's take it a step further and really serve that client a little differently than other people are doing it. And you're going to learn how you can do that. Wills versus trust, these are the two main items, but just because you have a will or a trust, you're going to have to do some other things in addition to that. Because in my world, nothing happens automatically. Just because you have a will or a trust, that's not likely enough. You got a good start, but we got to talk about the assets that the clients have or that you have. What about the assets? And if you don't address the assets correctly, just because you have a will or a trust, we still might end up with some problems in the future, because these assets are not going to fix themselves. We have to make sure the assets are in sync with the estate plan. Okay? Am I doing okay here with my speed? I know I'm rolling here. Kevin, is this okay?
Yeah, perfect.
Okay, we're going to keep rolling. The biggest problem in my industry, folks, is the Bermuda Triangle, and you're looking at it right here. So lawyers are usually drafting wills and trusts, and that's fine. They do a good job. But there's other people, this whole blue bubble here. I would put you in here as well as realtors and brokers and life insurance agents and financial advisors and bankers. These people are helping your clients manage their wealth. But these people are not lawyers. Lawyers draft the legal document, but what does that mean for all the advisors that are actually managing the assets? And what about taxes? is anyone thinking about taxes, which most lawyers never talk about taxes. And most of you know, as realtors in the state of Minnesota, if your assets are over $3 million in total net worth of the estate, well, now we're dealing with an estate tax that we may not have saw coming. And if there's no planning on that, if no one's asking questions, we might be missing an opportunity to save a tax, right? So anyways, the take-home message here is we got to make sure all of the advisors in your client's life or in your life are actually talking to each other. The right hand must know what the left hand is doing when it comes to estate planning. We can't just go talk to a lawyer and think we're done. We got a lot more stuff to do. That'll make a little more sense as we go along. So just know we got to have a coordinated effort here among all the people out there. All right, they're all doing good work, but they don't talk very well together. And I would challenge any of you listening today, have you ever had your lawyer, your financial advisor, and your tax person in the same room at the same time? Most people would say no. So that's why things get missed and there's probate and problems. So let's keep rolling. Wills and trusts are really different. They're both estate planning documents, but how they affect all of these things is where we start to see the great divide come into play. And folks, I'm not here this morning to say wills are bad or trusts are good or vice versa. We're here to learn about the differences between a will and a trust because they really do work differently. One provides way more control and efficiency and protection than the other. One allows you to keep everything private. The other one is completely public. Okay, one has a better or a more impact on your beneficiaries on when and how they receive the assets or the inheritance that you're trying to leave behind. They both affect your executor differently. And if you folks, if any of you have agreed to be the executor for someone else's estate plan, and I would bet some of you have done that, I would challenge you, do you have any idea what that estate plan is? Have you ever looked at it? Is it a will? Is it a trust? What does it say? Who's in charge? What's, and again, what about the assets? So there's just a lot of ways these two documents differ, and we'll get into this down the road or in your personal review. We're just going to scratch the surface this morning for the sake of time. A will, folks, I'll leave the definition up here. Again, a will is not a bad document. There's a million wills out there, but they don't really do what you think they might do when the time comes. A will is really nothing more than a set of instructions to a probate judge. A will is you leave it behind, you say, well, I'm Kevin Sharkey, when I'm gone, I want to leave everything to my wife, and if she's also gone, I then leave it to my children in equal shares. And here's who's my executor or personal representative. That's kind of what a will says. Most wills, folks, are about 3 pages long. There's just not much to them. But yet we're talking about your entire life, your entire empire of assets and real estate and businesses and investments and life insurance policies and bank accounts and cryptocurrency and precious metals, all your annuities, everything you've acquired is a 2-page, 3-page little document. Is that going to be good enough when I'm gone? Well, most people think it is. And again, I'm not saying wills are bad. If any of you have a will, you've not done anything wrong, but let's learn a little more about that will. It's only valid after you die. It doesn't do anything really while you're living. It's not an incapacitation document. It's really for when you're gone. A will basically is a death document, and it's meant to be validated and interpreted in the court of probate. That's what a will does. That's the way they work. You may not want to leave that type of experience behind for your loved ones, and your clients may not either for their families. So anyways, that's the definition. We're going to keep rolling here. Again, this is both the question and the answer. One thing I want you all to learn about a will is the will has to be probated. So will you go to probate? Well, with a will, you go to probate. So I'm kind of having a little fun here with the question and the answer because that's the way they work. Your will cannot transfer assets to your loved ones, at least not immediately. It's just a set of instructions that has to be carried out under the direction of the judge down at the probate court. So you can't really do anything immediately. Eventually things will get transferred. Eventually we'll open up your rules and everything will go from A to B. But initially, that's kind of how wills work. So we just got to be careful on that. Here's my scary chart of probate. So I don't want you or any of your clients to go through this process. Probate is not a four-letter word. It's not the end of the world. But probate benefits courts and lawyers much more so than your family and loved ones. How do we start the probate process? I don't even know if you can see that. The very first step reads your will. It doesn't say read your trust. Well, why is that, Jeff? Well, because a trust avoids probate, but wills don't in and of themselves. They are a court document. And then we kind of make our way through the fun, lengthy, costly, and frustrating probate process until we get to the very end after everyone else has been paid first. Courts, lawyers, fees, creditors, and your kids and your loved ones are getting the leftovers down what's left behind. So some of you have probably gone through the probate process. This is formal probate. Okay, this is not informal probate. We can talk about that later on if we have some questions. But I just want to avoid the formal process because it's not very fun for the families. My own family went through this when my folks passed. And I wasn't in this line of work at the time, or I would have fixed it in 5 minutes. But we're going to talk about a transfer deed. They had a transfer deed for their property, but my mom and dad had 3 different parcels of land out in Delano in Wright County. And the lawyer that they worked with only put one of the legal descriptions on the transfer deed. So me and my 3 siblings only got one of the parcels. The other 2 still had mom and dad's name on the deed. So we had to go through this goat rodeo, which took 13 months and costed $3,300. And that was back in 2013. So we're just trying to avoid this, okay? There's some resources out there. I'll let you get the slides from me and you can research this. It talks a lot about some of these documents and how to avoid probate and wills and trust. This is the Attorney General of Minnesota saying this, not Jeff. Having a will does not avoid probate. In this document provided by the Attorney General's Office of Minnesota. So just make sure we understand this stuff. And here we go. Let's talk about real estate a little bit. Unless real estate is jointly owned, okay, or unless it's placed into a trust, it must be probated. And that's formal probate. Even if it's a $20,000 weeded vacant lot on the corner of Main Street and Fifth Avenue downtown. Real estate will always go through formal probate if it's not addressed correctly. So we have to do some things in addition to having a will. All right, now joint ownership is fine on the first death. So Kevin, if you and your wife, is her name Linda? I can't remember.
Yeah, Linda.
Okay, I remembered correctly. You know, I'm not getting any younger either. I don't have as much gray hair, but anyway, so if you and Linda owned your property jointly and Kevin, you punched your ticket, it would be Linda's. All of you know this as realtors. No probate, no problem. We had 2 owners yesterday. Now we're down to 1. Well, that's only good on the first death. What happens when Linda passes away? And now what do we do with the property? So joint ownership is not good enough for estate planning because your kids, where you want the house to end up, they're not a co-owner, are they? And we got to make sure they get that ownership. You can certainly put it in a trust. You could also add, I wish they'd add another option here. You could utilize a transfer on death deed, but that will avoid probate. But transfer deeds have pros and cons. Let's talk about a transfer deed, pros and cons. I'm going to give you 3 real quick, 3 pros and 3 cons to a transfer deed. One good thing about a transfer deed is it's cheap. Okay, it's cheap. and they're easy to get. You can download it yourself and do it yourself, especially as realtors. So it's cheap and easy to get. It avoids probate, okay? And the kids are going to get the house. All right, so those are good. All right, because we do want to avoid probate if we can and get that asset to the children. Some of the negatives of a transfer and death deed, I say it this way: the good news is with a TOD, a TODD, transfer and death deed, the kids are going to get the house when you're gone. Sometimes the bad news is the kids are going to get the house when you're gone. Because what if the kids are not ready for the house? You pass away on a Sunday, you have a transfer and death deed going to 3 kids. They wake up Monday morning, and whether they like it or not, they're the owner of the house. It happens relatively quickly. They can't stop it. They can't pause it. They have this big asset that dropped into their lap, God forbid, right in the middle of a divorce, or right in the middle of a creditor, or right in the middle of an injury, or right in the middle of them putting their children through college and filling out FAFSA applications. Now this asset that I must own because you forced it into my life, yes, I avoided probate, but it might have caused some other problems. So there's no warning or protection. It's just going from A to B. That's one potential negative. Another negative is when the kids want to sell the house, guess what? As realtors, it takes 1 to buy, but 2 to sell, doesn't it? So what if all 3 kids are married? How many signatures are we going to need? Most likely 6, right? We're going to need the 3 children that actually own the house, but their spouses. Every title company in Minnesota is likely going to want that spousal signature, aren't they? And what if the spouse can't be there? What if the spouse is mad at your child? What if we can't get 6 people to all agree? So these are, I'm going to take something else. So that's a second negative, is that we need multiple signatures, right? And the third potential negative is the insurance might not pass through because the client might not have notified their insurance company. Okay, so there's pros and cons. Those are just a couple each. Let's wrap up a will quick. A will, most of the time, wills are not bad, but we have to address the assets. So in other words, every asset you own must have a beneficiary in place, because the will is not a beneficiary form. The will is just a set of instructions to a probate judge. So if you want to avoid the lengthy probate, just make sure all of your assets are set up with proper beneficiary designations, because the beneficiary will then take that asset from A to B when the time comes. So everything needs a beneficiary if you have a will-based plan. Does that make sense? Hopefully it does. But most people don't know that. Most lawyers aren't giving you the 2 sides of the coin on a will. They tend to push wills because lawyers benefit from taking your family through the probate process, and we don't like that. I'm not saying they do it on purpose, but that's the way a will works. The kids normally call the lawyer who drafted the will. And now the lawyer's got a 13-month probate process where they're going to make far more than they ever made drafting the initial will. I heard a lawyer say at one point in the past, wills are nothing more than a future accounts receivable for a law firm, because they're banking on the probate happening. And I don't want that to happen to you or your clients. So let's avoid all of these negatives by making sure everything has a beneficiary, and then those assets will not go to probate. The only risk now you're taking is the beneficiary is going to send that asset to B, whether B is ready for it or not. And if we're talking about several different assets, all coming at once, because beneficiaries work relatively quickly after the death of the owner. Now we got all this money dropping in like missiles, into the child's life, and it might not be great depending on what they're going through at the time. So beneficiaries do work well. They avoid probate. The money's going from A to B, but I want you to think a little more carefully. What if the kids are not ready because they have no way to park it or pause it, or they have to take it into their life? So if it's not much money, no problem. If it's a simple house going to 1 kid and they're not married, do a transfer and death deed. Do a beneficiary on the bank account, on your investment. Everything needs a beneficiary. Okay, but how do you handle a beneficiary on your business? Okay, how do you do the beneficiary on your crypto? And all these other things that people don't know about, and that's kind of where the problems arise. We get back to the Bermuda Triangle. Lawyers don't know anything about some of these other circles, and the people that are helping you manage your money are not lawyers, and they can't give you legal advice, and they really cannot say you need to do a will or a trust. So we just get a lot of trouble, and that's why typically with a will-based plan, these are usually a yes, and I want them to be a no. So some people, well, these are just some fun quotes on a will. I'm gonna bypass that. We're gonna talk about the other option, which is a living revocable trust. And I know we're cruising fast, but I'll have some time for questions here at the end. Okay, am I doing okay?
Yep.
Okay. There's all kinds of wills and there's all kinds of trusts out there. Most people do a living revocable trust. You set it up while you're on the right side of the grass, and revocable just means you can change it. You can update it. And that's what most people start with. A trust, when it's done correctly, is a completely different approach to your estate plan. People say, Jeff, before we get into this, people say, Jeff, my brother-in-law said I don't need a trust, or whatever. So-and-so said I don't have enough assets to consider a trust. Folks, if I can just call it blank here, it doesn't matter how many assets you have. I know that's important to you and to me, but the flex in life is not how much money you have. The flex in estate planning is what type of plan do you have around your empire, whether it's big or small. We're talking about, do you have the type of plan that will do the job that you want it to do? And that's where trusts sometimes come into play. A trust is an entity that's created. It's like a business you set up. The trust will have a name. It will have a tax ID number. It will have a date of activation. Just like a child has a name, birth date, and social security number. A trust is an entity, and as such, it can own assets. It can hold them. It can possess, protect, and eventually pass your assets to your children or charities or your named beneficiaries. But we want everything going to the trust first. A trust cannot protect or transfer something it doesn't have. And Kevin, this was a big light bulb for you and many others. If you have a trust, you're only half done. I describe a trust like a fence. We're going to build the fence. The lawyer's going to draft your rules. The trust says who gets what, who's in charge, all of that. Very similar to a will. But because it's a trust, it's an entity. And now that we've got this entity established, we need the entity to own the asset, right? So we got to put your animals inside the fence. The lawyers just build the fence. Lawyers just draft trusts, and they normally don't help you get all of your assets properly funded into the trust. And this is the critical component. Kevin, I heard you talking before we started to your colleague there about you got to get things in the trust, and that's exactly right, because the trust can only protect animals that you put inside its fence. If you have a beautiful trust, but you still own the property, your name is still on the deed, well, that's a cow that's outside the fence. And if you pass away, we still might have to probate the land because your name or your client's name is on the deed. See where I'm going here? So we have to make sure the trust is properly funded once it's established. The lawyer does the work first. We build the fence, we draft the documents, then we get your assets funded or transferred or connected to the trust. That's how that works. And when that's done correctly, a trust is a much more elegant, efficient, private estate plan for your family. It avoids probate. There's no publicity. We don't need all the children involved going down to the bank, filling out the same claim form to get their inheritance. We have one person doing all of that work. It's more efficient because one person's chopping the wood, not 3 or 4. We avoid multiple signatures because we don't need the spouses. Why is that? Because we're going to put your house, oops, I went too far here. We're going to put your house in the trust. We're going to get your cow inside the fence, and one person is in charge of the trust. And that person now can sell the house out of the trust, and we don't need that person's spouse, and we don't need their siblings or any of the other beneficiaries, because I'm operating on behalf of the family trust. I can't change the rules when mom and dad is gone, but I'm in charge of the trust as the successor trustee. And if mom and dad got all their, I know this is a little corny, but I'm trying to make the point here, right? We got to get the animals in the fence. And then if I'm in charge of the trust, I can liquidate these animals out of the fence and distribute that money according to the rules of the trust. And everything's being done under the direction and under the ownership of the trust. I'm just pulling levers. I'm just turning dials. I'm just settling the affairs for the family. But see, I don't own the asset. We're not doing a transfer deed to people, right? People are going to wake up on Monday morning and be the owner of the home on a transfer deed. With a trust, guess who's the owner of the house? The trust. We're going to do a quitclaim deed and retitle the property, and now your cow is inside the fence. And then when mom and dad are gone, when they pass away, the trust doesn't die. The trust is still here. It's an entity, just like a business is still established, and the trust still owns the house. So there's no probate. The owner is still right here. It's the 3-ring binder on mom and dad's table at home. And then I can start settling the affairs of the estate. But I have to just make sure assets are retitled, or we're going to update beneficiaries. So put it this way, then we'll wrap it up. I've got a trust. I've got 3 children. 2 of my 3 children are now married. Folks, you can do whatever you want, and I'm not here to say what you should or should not do, but I know enough about this after 10 years of dealing with this. You could not pay me to do a transfer on death deed to my 3 children. I wouldn't do it if you did it for free or paid me. I'm not doing it. I don't want to drop that asset into their life unannounced the day after I'm gone, and I don't want 5 people being forced together, and I don't want to give my 2 in-laws leverage over my home. So I retitled my house and just put it in my trust. And my daughter Hannah is in charge of my trust as the successor trustee, and now she can sell the house. I go from 5 signatures down to 1. That's control, isn't it? That's protection. And here's the last thing I'll say. What if one of my sons doesn't want their inheritance at the time? When Hannah's about to write checks and distribute, she sold my home, she liquidated my bank accounts, she's got everything back in the trust. And she says, Ellis and Aiden, Dad, we each get a third. Aiden, how you doing? Do you want your 1/3? He might say, Hannah, you know what? I don't want my 1/3. I'm dealing with something in my life and it's none of your business, but I don't want my money from Dad's trust. Leave it in trust, because I'm going through a divorce and I can't be divorced over something I don't yet own. See, I don't own it yet while it's still in trust. Your property and all the assets can just stay walking around in the fence until it's ready to pull them out and distribute it. So I know we're going super fast, but
Can I ask a
you have to
couple of
listen
questions?
fast. Yes, go ahead.
Well, inheritances aren't part of a divorce anyways, so I'm a little confused on that, but we'll come back to that. But if you put it in a trust, I know that if I get incapacitated, there's a look back period.
Yes.
Do I still own it if it's in a trust, or can I avoid
Yes,
that
you do.
look back?
That's a good question. A
Okay.
revocable
So-
trust is a pass-through entity that they're all still your animals. You'd have to consider a different type of trust to shield the assets from Medicaid and the look back. That's a whole different conversation for another day, but that's a good
Okay,
question.
and then finally, if my lender is lending on my net worth, that still counts as my net worth then, because it kind of comes back to my last question.
I don't
When I
understand
look
that
at my
question.
liquid assets and my property owned, it's still property that I own, even though it's in a trust.
Yep, because it's your trust. You're the grantor and you're the owner. You're the cowboy in charge of your fence. All the animals are still yours. The trust is really probate avoidance for the family. The trust is trying to provide efficiency and privacy when you're gone, but you still own everything. And you'd have to spend it down. And yeah, and divorces, I can tell you now, yeah, divorces, estate assets are not normally available to divorces, but I'm telling you right now, that doesn't keep people from suing and trying to claim against them. So it happens all the time. If a soon-to-be ex-spouse knows that you're getting, you know, $500,000 from your parents, she might just hang around long enough while you're still married to have more of a marital right or marital interest. And even if the divorce is pending, they're still going to put a claim against the estate. We've seen it happen countless times. So a trust does work better to protect that because you don't own it. If you're named as a direct beneficiary, that's a whole different subject now because you're going to have to take that asset into your life. It's just a little more exposure. It's a little more risk, but the point is still well made. There's still some guardrails around divorces, but I'm just here to tell you they're going to try. Usually they will. So that's a good question. We'll talk about nursing homes and shielding assets another time if you want, Kevin. Here's just a little quick rundown. Again, there's pros and cons to this. Trusts sound great, but they cost more, but that's because they do more. And it's up to you to decide what's best for your family. We do wills all the time. It just depends on the assets and what your wishes are and the family. But here's just a little quick rundown that you can take a picture of or when you get the slides. We just want you to be aware of the differences here. So that's pretty much what we're going for. As we wrap it up, one thing I want you as realtors, you know, conversation starters, if you really want to add some value to your clients, one simple question at the closing. Hey, John and Mary, thank you for letting me be your realtor and your agent. I'm glad you got the home, your dream of the house of your dreams. Hey, as we wrap it up, what's your long-term plan here? Hey, tell me, I want to make sure it's protected. Now, do you have a will or a trust? And do you understand how to protect it from probate? A simple question like that can mean the difference between you being a rock star and a lifelong client that they're going to think about because you asked a simple question about something a little bit outside of your wheelhouse, but you don't have to be the expert, but just asking them so that it doesn't end up in probate because most real estate does. I'm sure some of you have dealt with property that has been kind of stuck in the probate purgatory, you know, and then, and I know sometimes you can still get it on the market and do certain things, but just a simple question like that is just something I want you to think about. Because it's important. Your clients are dealing with this. You might be dealing with this. There's a lot of assets transferring to your children. Trillions of dollars are going from the baby boomers now to the next generation. And most kids sell the assets. They don't always keep it. They sell the cabin and they even sell the business. Sometimes they're not sure what the taxes are. No one talked to them about it. They still view it as a little mini lottery. There's no planning. They might be dealing with the Minnesota death tax. So these are just things to be thinking about. If you find your clients dealing with something like this, if they're over the $3 million limit before they sell a highly appreciated asset or something like that, just tell them to hit the pause for a second. Let's talk about the tax ramifications because there's all kinds of cool things we can help you with to serve that client, whether it's a charitable remainder trust, whether it's a donor advised fund, whether they're doing some gifting, some different things just to affect taxes and try to help the ultimate beneficiaries get more. So anyways, that's it. A lot of stuff here. That's what the review is for. If any of you want to follow up with us one-on-one, we'll certainly slow down and take our time. And if you want to just take that further after this morning, just visit the website and it's right there. I want you to know those conversations can be phone or virtual or in person, totally up to you. Our new office is here on 55 and 169, so we're right in the heart of Plymouth. This is our prices. I don't want there to be a pink elephant in the room. Yes, this is how we keep the lights on. We do this every day. Dare I say our team's pretty good at this because we're going at it from those three lens approach: legal, finance, and tax. The left-hand price is for a simple will for a single individual. If you're a married couple, to get a will-based plan is a flat fee of $2,500 because we're doing 2 wills and 2 powers of attorney and 2 healthcare and a deed, and then we'll still talk about your financial assets. So these are flat fees, and it covers everything, including the lawyer. Trust costs more because they do more. There's a lot more documents. We're going to work with you to get your animals inside the fence. A single individual is $4,200. If you're married, it's $47,000. There's a lot going on here, but we're kind of preparing the your plan so it goes pretty smoothly. And we're going to teach you how to manage it on your own, how to get new assets put inside the existing trust. If you buy a new house in the future, it's so easy to get those in and out. This is just to get that foundation laid and built up, but you're going to manage it in the future. Anyways, those are our prices. And with that, I'm going to stop sharing and we're going to talk a little more if there's any other questions. So thank you for letting me go probably faster than I've ever done before.
So I appreciate that because normally our meetings are an hour long. I wanted to make sure we had enough time for Q&A. So I do have a question, Jeff, about rental properties. Should rental properties be in the fence or outside of the fence?
Rental properties should likely, and I'm not a business attorney, you would likely, you'd have to consider if you want to own it under your personal name or under an LLC. Our lawyers would say it's safer for you long-term if it's owned by the company, by LLC for some liability protection. And now if you have the company that owns the property, that's an asset. How do we get the business in trust? And we have a way to do what's known as an assignment of interest. So the short answer is yes. All of your animals, no matter what type of animal it is, should likely be inside the fence, okay, your trust. And we'll make sure that gets in there. So the answer is yes. You still run your company day to day, pay your taxes, nothing changes, but it's a nicer way of just making sure that asset doesn't get stuck if the owner of the company passes away. All right, because that company would own the property. Now, if you don't have an LLC in place and you just own it under your personal name, we will absolutely be doing a quitclaim deed or a transfer deed into your trust to protect that real estate.
Okay, so how about retirement funds? How do you get a retirement fund? Can you have that assigned into the trust?
You don't have an IRA assigned because that's a qualified investment. And most of you have a 401k or an IRA or a 403b. Great. We love them. They're tax deferred, but a trust cannot own those types of accounts. You have to own it. It's an individual retirement account. And what we do then is we simply change the beneficiaries. So you're still the owner of it and it's your money throughout your life. But when the owner dies, instead of Fidelity writing 3 checks to 3 different individuals who all got to come forward and fill out the claim form, we would likely work with you and your advisor because we're going to talk with your advisor and make sure we're all on the same page. We would likely just name your trust as the beneficiary. So my 3 kids are not named on any beneficiary on any financial asset I own. My trust is named on everything. It's like I got 4 children and my favorite kid's name is Trust because that kid's getting everything when I'm gone. And the trust says where and how to distribute that money when the time comes. And then we get that added benefit of the money kind of staying in trust for a time period so the kids can better manage their own inheritance to a degree. Okay. So that's a good question too. So qualified investments you're still going to be the owner, but we're going to talk about changing the beneficiaries.
I got a question. So
Go
say
ahead.
you have your trust and now you get married. Does that change anything?
It really would change things in the sense there's marital rights and spousal interests that come into play on some of the assets. Minnesota, however, is a common law state. We're not a community property state like Wisconsin. But yeah, you would likely update that. You'd probably do an amendment. And your new spouse, maybe they have their own trust. You could probably keep those same structures, do a little amendment to reflect each other and change the distribution, but you probably won't have to start over. That's a really good question. Same thing if you got a divorce. If you had a joint revocable trust, you're happily married, and then, I didn't see my divorce coming back in 2009. I didn't have my trust back then, but I would have had to update or amend my trust and change it So you're always able to do that. That's why it's a revocable trust. It's not an irrevocable. They're a little bit different. We'll talk about them another day if you want to.
Yes.
Go ahead, Rick.
So just to clarify, when you put your retirement money and the beneficiary as the trust, the trustee's successor or whatever that name is, they don't have to distribute all that money at one time. Do they?
That's a good question. Yes, they will, depending on the type of asset. So IRAs and qualified plans are very different. They have to come in the front door and go out the back door within 9 months of the owner dying. IRA money, folks, cannot stay in a trust very long. It's normally passing through on its way to the kids. So the only thing the trust does is kind of just funnel everything into one place. One person now my daughter Hannah can go get all my stuff, bring it to the middle, and then Hannah's going to have to work with her brothers, and they're all going to have to set up an inherited IRA account, just like they'd have to do if there wasn't a trust. So the end result, the kids are going to get your IRA. It'll be an inherited IRA account because it has to be the same type of a qualified account. And then they're going to probably have the Secure Act, I think says 10 years that they'll have, they have up to 10 years now to determine when they take all that money into their life because it is taxable. It's still taxable. The trust simply funnels it through onward to the kids. The trust doesn't pay any taxes on an IRA. It bypasses through. Our trusts always have that conduit language that we have our lawyers build in because we understand the financial world, and some lawyers don't have that conduit language, and now you are running the risk of the trust paying some taxes if you route your IRA through. So we'll get into more of that in your review, depending on what you're dealing with. But bottom line is it's okay to name the trust as your one and only beneficiary on everything. Just know that some of the animals are going to get pulled back out of the fence sooner than others.
So
Okay.
What's the tax consequences on an IRA? Because if it's a taxable account, you get a stepped up cost basis. Do you not get that with an IRA?
IRA is treated as, it's my understanding, I'm not a certified financial planner, I'm a certified estate planner, but IRAs are treated as ordinary income. Now a non-qualified, a brokerage account, if you got Apple or Tesla stock or something, that gets a step up in basis, but that's a non-qualified. So it depends on the type of account that you have. And we'll address that in the review, but IRAs are typically regular, ordinary income. And the tax that is paid, folks, this is important to remember, the tax that is paid on the IRA money you leave behind is going to be paid based on your children's age and income and tax bracket, not yours. If you're 80 years old and you're not using your IRA money, but we slow down as we get older, our tax bracket tends to be lower, and you're leaving $500,000 of IRA money to children that are in their peak earning years, that's the tax that's going to be paid on that IRA money when they take it out, not your tax. So we gotta be thinking about this. It'd be foolish to leave behind IRA money to children that are in a higher bracket than you. That's financial planning. That's not even estate planning. That's just a freebie that you get this morning from me. So we got to be thinking about this stuff. Again, gets back to the three circles: legal, finance, and tax. They all got to work together, or at least we think they should, for your estate plan to just make sure things go smoothly. Taxes are a huge issue.
Mariana, you got a question?
Well, yeah. You had said in your last slide with your company that you do a tax review. What does that entail?
Yeah, we're not doing tax returns. Okay, we've got CPAs we refer to that we know that do our own taxes, but the tax lens that I'm looking through are what we're already talking about. What assets do you have? Folks, all of you in the room hearing me should have an idea of what amount of your estate is going to be taxable to your loved ones. All of you should know that. And if you don't know that, find out. And if this asset's taxable, if that asset's taxable, so we're looking at the type of taxes. We're going to help you uncover or discover if you are a candidate for a Minnesota death tax? Are you above the $3 million threshold? Are we dealing with income taxes on a qualified investment such as a 403B or an IRA? What about capital gains on highly appreciated assets that are non-qualified? You know, like selling a house, right? Now, some of this, if it's your homestead, we all know we get the exclusion, but not on a rental property, right? So we are always looking at taxes and how it affects your estate and your beneficiaries. And we're always trying to make sure we're minimizing or eliminating them if we can. So, but we're not doing your standard tax returns that are coming up here in April. I don't want to do your tax return.
Do you have a recommendation to who could?
We do. We got a couple of folks that we work closely with. You can have a cup of coffee with them if you want it. I just talked to Lance the other day. So some CPAs are not open for business. These two are. So yeah, we have a referral there, and we've even got financial folks too that if you don't have a good advisor. But again, we're not here to replace your advisor. We're here to complement what they're doing. We're here to come alongside and kind of connect those other dots for you that likely have gone unconnected up to this point. Good questions, folks. These are really good stuff.
I've got another one. If I've got small children in a cabin and I don't want them to sell it right away, I think that's how you use a trust. Is
You can use a trust to add other controls and protection and guardrails, and you can meter things out. You can force them to keep it in trust for 10 years before they sell it. You can require them to have first right of refusal for their siblings. You can do all kinds of stuff. See, that's what a trust can do. It's your rule book. It's like a blank slate, and you determine how your assets are going to be handled. You can have more control from the grave than even sometimes when you were here. And that's exactly what a trust does. So a trust is not about, are you starting to see? It's not about how much money it's about.
Question?
Go ahead.
Yeah, so the question is, if I want to give them money to, because there's overhead associated with it, how are you then handling a trust to give them some money in the interim?
Great question. First of all, we're going to retitle the cabin. So the cabin is owned by the trust. So the cow is inside the fence. And you're probably going to have a bank account established in the future under the name of the trust. And some of your investment money or some of the other liquid money will be put into that trust bank account. And your kids are the successor trustee. It's not their money. It still belongs to the trust. But they use that money for the benefit of the trust settlement and for the trust assets and for a cabin that has maintenance and taxes and things like that. So all that's being done under the direction, the control, and the privacy of the trust. And all the while, it's not the children's money until they take their inheritance and retitle that property out of the trust and put it in my name. Now I own it. Now it's on my chopping block. But I'm not going to do that if I'm dealing with, creditors or gambling problems or special needs, minor children. There's all kinds of reasons why some folks are leaning into a trust, because it can address these types of things. And a will can't. A will can't own anything. And all that kind of gets worked out through the probate process, which isn't bad. It's just a different way of settling the affairs of the family.
Thank you.
Good questions. Anything else as we wrap it up? I know we went super fast.
Yeah, Jeff, I know that a lot of people here are going to want to get your contact information. So do you have a slide that we can take a picture of, or can you hold up a business card? I know a lot of people want to be able to have access.
The easiest would be, let me move my screen over here. Let me come back here. Yeah, I'll show you that one. Really, I would just go to the website here and it's just Generations, LF for a law firm. So my card, they're trying to, Kevin, they're slapping my wrist now, because years ago when we weren't quite as much going on, I was able to, I had my cell phone on my card and all that. They're trying to route everything through the main line here, but you can certainly just ask for me if you wanted. The reviews that when you come in for that review, it'll either be with me or one of our attorneys who are going to be even more qualified than I to answer your questions. So, but that's how you start. I don't mind any of you emailing me. My email address is just my first name. It's Jeff. I don't have a slide ready, but it's Jeff.Litfin. My last name is L-I-T as in Tom, then F as in Frank, I-N. and I'm not even going to put it up on the screen. It's probably, so jeff.litfin@generationslf.com. Kevin, you've got my email. You can share that with
Yep,
anyone on your
yep.
team. And I'll make sure I get the slides sent out to you right away here when we're done.
Yeah, we still have a couple more minutes if there's any more questions.
I'm here as long as you want me to be here. These are really good. I love the Q&A because sometimes it's we can be a little more specific. Anyone with minor children or special needs, those are things we have to be careful of, even as a younger family, because you can't name your minor children on a beneficiary. Remember I said if you have a will, the only way to keep the assets out of probate is to have a beneficiary on everything. Well, you can't name children on a beneficiary, and minor children cannot own real estate. Well, now what do we do if anything happens to you and your younger spouse? You know, minor or children with special needs should not be listed as a beneficiary. You're going to mess up their government assistance. I'm dealing with that right now with a client from last week. Their son is getting medical assistance. They got 6 kids. One of them cannot be named as a direct beneficiary out of they already have a trust. They're amending it and they're changing how their son, Ben, is going to receive that money. It will be routed indirectly to him so he can maintain government benefits. So these are all little nuances as well.
I have a question, Jeff. I
Yep.
think if you do a consultation with one of us or someone who's looking for the service, do you offer advice on what people should do? Like someone who's got a 20-year-old and an 18-year-old, a 21-year-old and a 19-year-old, like what's appropriate at this age? You know, that kind of stuff, that kind of direction.
Yeah, that's what we uncover. That review, we just call it a simple review, whether you have documents or not, even if you have existing documents, if you wanted them reviewed, because folks, we're trained differently. I can tell you what kind of trust or will you got in about 5 minutes. We'll tell you if it's lacking any of the language or any protection provisions. And so feel free to come in, even if you have documents, we're happy to review them. My commitment to Kevin, where I appreciate him and in opening us up to your team, there's no way I'm going to solicit any of you or push any of you. We're here to just milk for as much as you can. And yes, we're going to discover, we have some discovery questions in that review where we talk about that. You know, what do you want done? Tell me about your family. Tell me about the assets. Are the kids struggling? Are they doing okay? Do you want any control or protection? Do you want to give them it all when they turn 18? Or do you want to meter it out over time and make them grow up a little bit? You know, these are things that we uncover and talk about in those reviews. They're very beneficial. And again, they're complimentary. You don't have to do anything at that. It's just a way of coming forward and being a little more specific. Because again, this is a public, we can only talk about so much here. This isn't the place to complain about your brother-in-law you don't like. We'll do that in the review. So yep, we get into all of that. They last anywhere from a half hour to an hour and a half. It's really up to you. And that's how, again, if we were there normally, I would be, I don't have one with me here. Yeah, you know, you would have this yellow card you'd fill out, you know, and well, I don't even know if you can see that, but normally you turn this in for a review, but for now, just go to the website and just kind of request a little consult on that blue button. Same thing. It's just, in fact, it's probably easier doing it that way. Now, I'm not sure if you'll meet with me or Andrew or Barb or, you know, one of our attorneys or Mary. Mary's another estate planner like me, but we all do the same thing in those reviews. And you'll be in good hands no matter who they set the appointment with. You can certainly request me if you wanted, but doesn't matter. We're going to take care of you no matter what. Anything else?
I'm going to toot your horn a little, Jeff. I just went through this process in the last 3 or 4 months, and from the review all the way till the end, they walk you through it. But just to clarify what you were saying, they ask you questions that tailor make it for your needs. I chose the trust because as of right now, everything's going to my siblings, but one sibling's deceased, so it's going to, people included would be like 12 or 14 signatures. And I don't want some of them messing around in it.
Yeah.
You know, and plus, if they don't all agree and say, well, I don't want to sell it now. Well, then what do you do?
Right.
You know, it's in the trust, but I mean, if it's not in the trust, it kind of has to be done.
Yeah.
Well, I appreciate that, Rick. I mean, everyone's Everyone's different. Folks, you don't have to do a trust. There's no law that says you have to do that. We're not going to say you need to, but we're going to explain how they work, the pros and cons of each for your particular situation. And by going through that process together, you know, your steps kind of get illuminated. People just kind of realize, let's do this, honey. This is, I like this better. And that's kind of the way it works. But we're here to do whatever you want. We help family, just a power of attorney here and a transfer deed over there. And I mean, we do anything you want. But we start with learning. We want you to learn and be educated and be empowered. And that's where I'm proud of our team. We really believe in the education much more than the standard, you know, others out there that might just scratch the surface. There's just more to it.
If I could just add one little thing too, is this is a really good opportunity for agents. If you do client appreciation parties, you know, if you rent out a big room or a company rents it out, Jeff will come on out and do a presentation for your customers. And it's a really nice way to get some recognition for yourself. It's a good service. So something to think about.
That's a great point. That's why we're doing it. And Kevin, that's why you wanted to bring it to your team. So folks, this can really help you. Over the years, we work with a lot of realtors. There's probably only been about a dozen that will do these types of client appreciation. Bring us in. We'll do a little quick class on wills or trusts, or our main class, Who Will Inherit the Mess. We talk about powers of attorney and healthcare directives. We don't charge for that. We appreciate our partnership. It's a way for you to just serve that client more holistically and help them protect these important major assets in their lives. Because folks, people just don't know this stuff. They all think I got a will done, so I'm done. And there's just more to it. And you have such a unique opportunity because you're helping them buy and sell the primary asset that gets screwed up after people pass away. So yeah, you can definitely put a feather in your cap and help you just differentiate yourself, as I said. So kudos, Kevin. That's a great point. And I'd be happy to work with any of you on the side if you wanted to do your own little workshop. I've done it multiple times before, you know, with other people. So we'll get a little class together. Well, heck, I'll even help share the cost if you want to get some treats or something, or if we got to rent a room, we'll partner with you and we'll do a workshop together just to take care as a value add or a thank you for your primary clients. Because I'll guarantee you they got real estate or businesses or assets that are not properly protected.
Awesome. Well, Jeff, thanks so much for your time today. We really appreciate it.
All right, everyone. Well, thank you. I know it was a lot, but I appreciate you listening, giving me an hour of your morning here, and I hope you felt it was a good investment of your time. I'm grateful, Kevin. We don't take these opportunities for granted, so thank you for allowing us to come in. Just follow up on the website, and if you're going to request that consult, just say, hey, I was in the webinar with Century21, just so we know what class it was, because we have people contacting us from other workshops, but I want to know that it came from here. So with that, I'll sign off, and Kevin, I'll get the slides to you, and let me know of any follow-up questions or concerns or issues. I'm here to help in any way we can, okay?
Sounds good. Thanks again, Jeff.
Thank you all. Have a great day. Okay, bye-bye.